Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have an interesting docket for you today. First, I want to thank everybody for joining us last night for our after hours, as well as our Patreon show as well. Please go check it out. All right, first on the docket, an update on the missing boys, Orrin and Orson West. Arrests have been made. An update as it relates to Alec Murdaugh. Things aren't going so well. Juror 50. You know, remember the Ghislaine Maxwell? Well, suddenly, I guess those constitutional rights are important. Scott Peterson, do you believe the juror in that case? She was granted immunity. Should we just give Peterson a new trial now? And if you like gory, true crime stories, have I got one for you today? And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It is March 2nd, 2022. Can you believe it's already March 2nd? Well, you know the drill. If you haven't done so already, please hit the subscribe button. Hit that little bell so you receive notifications when we go live. And remember, you can always listen to us anytime by downloading us on your favorite podcasting app. Before we get to today's show, though, let's give a big shout out to our sponsor, Baked in Colorado. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Okay, have we got an interesting docket for you today. First, there's been an update as it relates to the disappearance of Orrin and Orson West. That's right, last night we brought it to you in our live show, Breaking News. The case of the missing boys from California, Orrin and Orson West. Murder charges were filed last night against their adopted parents. They're both charged with 2 counts of second-degree murder, 2 counts of willful cruelty to a child, and falsely reporting an emergency. Now, both are in custody, but little is known as to the whereabouts of the children. Apparently, the bodies have not been found, but they are presumed dead. They're both scheduled for an arraignment tomorrow. We will be following this case as it goes. As you may recall, Orrin and Orson West are only 3 and 4 years old. It's a tragedy that never should have happened. They were adoptive parents, and their real mother wanted them. May not have been the mother of the year, but she would have taken the kids back from what we can tell. It is a tragedy in the making. So we'll continue to follow this case as information develops. All right, next on the docket, Alec Murdaugh. Well, his attorneys, Mr. Harpeltunian and Griffin, filed a lawsuit Monday in the United States District Court in South Carolina, which ironically we were just talking about on our live show last night, and showed you some pictures of one of the courtrooms that I was in. Beautiful courthouse down there. Anyway, they filed this case in South Carolina to prevent Richland County from releasing additional jailhouse calls under the Freedom of Information Act requests that were being given. And they are citing the federal wiretap statute to basically make that happen. Now, the founding editor of Fitz News, it's a news media company down there in South Carolina. Well, they are responsible for obtaining published excerpts from 11 phone calls that Mr. Murdaugh made from jail. They believe that these were public records, hence they made the request. And guess what? so did the public entity which supplied them to Fitz News. And Fitz News claims that they will continue to push for the release of all government records that are not protected under the attorney-client privilege. Now, the attorneys for Murdaugh argue that Title III of the federal wiretapping statute prohibits the disclosures of recorded telephone communications of inmates to the public in response to those records requests. However, in 2003, the United States Court of Appeals ruled that Title III does not prohibit the disclosure of such calls, and therefore the calls are not exempt from the Freedom of Information Act's request. Now, the attorneys for Mr. Murdaugh also point out that in the jail orientation guidebook, inmates at the jail are told that their calls are recorded and monitored and that they are not informed that they can be provided to the public. I'm not sure about that, but either way, they are being recorded. They're advised that they're being recorded, and it is a public agency. Either way, Murdaugh attorneys are going to great lengths to keep the public from hearing these calls. The attorneys apparently went on national TV and admitted his client is a drug addict who stole millions of dollars from his former law firm. So this makes you think there must be something really bad in the next round of jailhouse calls. I can't wait. And in a little bit more Murdaugh news, agents investigating the whole Murdaugh murder saga conducted interviews with interns at the Peter Murdaugh's Parker, Elsroth, and Dietrich law firm known as the Parker Law Group. Now, the interns, or runners, people tasked with kind of menial tasks in a law firm, such as delivering documents and packages and never asking what may be inside of those envelopes. That's right. I started out as a runner in a law firm in college, and that's pretty much what you did. And you made lots of copies, and you made lots of runs to courthouses, filing documents the old-fashioned way. Well, the two PMPED runners interviewed this week by the South Carolina Law Enforcement Division, also known as SLED, was 22-year-old Austin Harder and 22-year-old Nate Tootin, were both assigned to Alex Murdaugh during his tenure at the firm. Harder is no longer employed by the firm. However, Tootin still works there, and his hours were recently increased. Tootin also says he dreams of attending the University of South Carolina Law School, once attended by Buster Murdaugh until he was kicked out for cheating. Apple doesn't fall far from the tree, allegedly. Now, Tootin's name also appeared in the deposition tied to the Mallory Beach civil suit. Tootin was apparently not involved in the boat crash, but may have been with Paul earlier that day. Neither of the interns nor anyone at the Parker law firm have been implicated in connection to Alex Murdaugh's alleged crimes, at least not as of yet. And even just a little more Alex Murdaugh news. Now a South Carolina judge is being dragged into the Murdaugh saga after being accused of allowing Alex Murdaugh to hide the $4.3 million payout from a wrongful death lawsuit regarding his housekeeper. Now, according to the complaint filed this week, Judge Carmen Mullen of Beaufort County had signed off on a death settlement for the housekeeper, Gloria Satterfield, who died after a fall at the Murdaugh home. The insurance company was supposed to pay out $4.3 million to the Satterfield family, but the family never received the payout, nor were they ever told about the settlement. So solicitor David Pasco has now filed an official complaint saying that Mullen signed off on the settlement, knowing that it would be kept from the public view. He's based his complaint off testimony given last month by Chad Westerndorf, the vice president at the Palmetto State Bank, an alleged co-conspirator in the scheme to steal $4.3 million from the Murdaugh's family housekeeper. Now, Westerndorf testified that Mullen signed the order knowing it would not be filed in the public record. By keeping the settlement private, Murdaugh was able to keep the insurance payout from his housekeeper's family and keep it from the family of Mallory Beach, the teenager who was killed in the boat crash involving Murdaugh's son, Paul. Now, Westendorf sat for the deposition that raised questions about Mullen's conduct on February 22nd by the Satterfield's attorney, Eric Bland, Ronnie Richard, and Scott Mongillo. Pasco's complaint and the sworn transcript are the first public allegations about Mullen, and she did not plan to immediately file the order approving a $3 million settlement for the Satterfield family in the court because of the publicity over the boating accident. Now, Westendorf stated that Mullen knew the settlement order for the Satterfield family was not going to be filed in the court because of the public scrutiny attached to the Mallory Beach case, according to the complaint. Mullen had recused herself from the fatal boat crash lawsuit in 2019, about a month before she signed the Satterfield settlement. And Mr. Pascoe said in his complaint, Judge Mullen's pattern of alleged conduct threatens to erode the public trust in our judiciary. Impropriety and dishonesty by members of our state's judiciary cause real harm to all South Carolinians. When wealthy and politically connected individuals are treated as privileged class by members of the judiciary, it erodes public trust in government and the fair administration of law. I cannot agree more. Absolutely. I've told you what is interesting to me about this case is that first, Alec Murdaugh didn't just start with one case of $4.3 million in a settlement. There had to have been so many people involved in this matter. Insurance companies, bankers, potentially even judges, it would appear. And so as people continue to dig, it's only going to get uglier for a lot of other people involved. There's no way he did it all on his own. There were people that were complicit, and I'm sure, I want to choose my words carefully, it wouldn't surprise me if people were paid for their participation or assistance in the case. So I guess we have to say the old adage, follow the money. All right, next on the docket, little Ghislaine Maxwell story. Well, remember that juror number 50, the one who thought it was so cute to tell the world how he influenced the other jurors in his particular case that he was sitting on? That's right, the Ghislaine Maxwell trial, of his own experience of being sexually abused and how it basically helped sway the jury. He didn't think that Ghislaine Maxwell was entitled to a fair trial because, she's guaranteed that under the United States Constitution. Well, guess what? Juror number 50, he now thinks those constitutional rights are pretty damn important. Why do we know that? He's asserting his Fifth Amendment rights against self-incrimination. So that juror is alleged to have not disclosed his history of sexual abuse during his jury selection. He is going to plead the Fifth when he is called to testify next week. Ghislaine Maxwell, as you may recall, was convicted on December 29th of the 5 counts of sexual trafficking and other crimes, but Maxwell lawyers said there was incontrovertible grounds for a new trial after juror Scotty David said he described being abused as a child during deliberations. Well, guess what? He's going to have to appear before Judge Allison Nathan in a court on March 8, and his lawyers say he will be there invoking his right not to respond to the questions. That's right, invoking his right guaranteed to every citizen under the United States Constitution. Isn't that funny? It's not so important that other people have their rights protected, but once it affects you, suddenly you're going to wrap yourself in the protection of the Constitution. Oh, I love when that happens. Now, after the filing, prosecutors immediately requested an order forcing David to testify. The hearing will be held to determine whether or not it will deliberate, which means that David's intention to plead the Fifth raises significant questions. The hearing next week will be held to determine whether or not it was a deliberate act, which means that David's intentions to plead the Fifth raises significant questions. I think the prosecution should start getting their witnesses lined up yet again, expedite those transcripts, because I think we're going to get a new trial. Well, we'll have to wait and see. Obviously, if there's one thing is for certain, if they're going to do anything they can to move the Ghislaine Maxwell case along, I'm sure it will happen. And who knows, if she gets a new trial, at least we know she's not going to be suicided just yet, like everybody else surrounding her. We'll have to wait and see. All right, well, let's jump then to Scott Peterson, because, well, we like to talk about juror issues. Well, the juror in that case, Rochelle Nice, one of the jurors who helped sentence Scott Peterson to death, admitted in court to sending him 17 letters, including one she sent from a psychiatric unit. That's right. Attorneys for Scott Peterson are fighting for a retrial for their client, saying that Miss Nice omitted crucial details about her past as a domestic abuse survivor during the jury selection process, also known as voir dire, a French term that means to speak the truth. Because Miss Nice revealed in court that she wrote more than a dozen letters to Peterson after she helped convict him of murder. What happened that night, Scott? She wrote in an August 2005 letter. What pushed you to the limit where you felt like you had to kill someone who not only loved you so much, but was carrying a part of you inside of her? Nice, who is testifying with immunity, which means anything that she says cannot be used against her in a subsequent prosecution for perjury or contempt, began writing to Peterson after he was sentenced to death row. In one missive written on December 17, 2005, from a mental hospital, she divulged that she suffered a psychiatric breakdown and had been locked in a crazy unit. Nice refuted suggestions during questioning that her infatuation with the case might have signaled bias. The prosecutor, David Harris, asked Miss Nice, quote, "Did you decide the case based on just the facts, not preconceived notions?" To which Nice replied, "Absolutely." Nice also once was granting a restraining order against a boyfriend convicted of assaulting her and claimed to be terrorized while pregnant by her boyfriend's ex-girlfriend. She failed to disclose this in jury selection process or on her questionnaire, and Nice was grilled on the stand Friday by Peterson's lawyer, Pat Harris, and claimed that although her boyfriend was convicted of assaulting her, he never actually did. Oh, so she didn't provide truthful statements to the police, which was grounds to convict somebody? However, Nice did admit during testimony that she failed to disclose being victimized by her boyfriend's ex-girlfriend, who slashed her tires, broke into their home, and threatened her. Nice's testimony has now concluded, but fellow jurors Justin Falconer could testify that Nice talked a lot about Connor, Lacey, and Scott's unborn son, referring to him as a little man. Peterson's attorney said he would also testify that Nice said she was having financial problems and that they joked about a post-trial book and movie deal. Yes, that's right, ladies and gentlemen. You tell me what to do with that stuff. I've talked about it. It is a pet peeve of mine when jurors are not honest, because guess what? It is a constitutional right to a fair trial. And if somebody starts out with a bias on that jury, leaning one way toward the other, and they haven't disclosed that, then, it's not a fair trial. It's one thing if it's disclosed and the attorneys make a tactical decision. Hey, I like I have a hunch. I think they're going to be a good juror. At least they made it based upon truthful information. But when they lie, I say hold them all in contempt and give the defendant a new trial. And when they hold them in contempt, they should get the bill for all the attorney's fees throughout the years because they lied. Bottom line. Have I made myself clear? I think so. Okay, let's talk gory, okay? And for all you true crime people out there, let's face it, this is why we're here, okay? Here we go. A 24-year-old woman in Wisconsin is behind bars after she allegedly smoked a little meth, and then killed a guy. It's alleged that she dismembered him and was taunting police that they were going to have fun trying to find all of his organs. So here we go. Her name is Taylor Schabusiness, Schabusiness. I'm sure I mispronounced that, but I think there are probably at least half a dozen ways in which it could be pronounced. Anyway, she was charged with first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. She's accused of choking the man to death during sex and then allegedly used a bread knife to dismember his body. Taylor then placed his head in a bucket while she dumped other large body parts in a large crock-pot box. This is all according to a criminal complaint. The victim's mother told police she heard the door slam between 2 and 3 a.m., and when she went to check it out, she found her son's severed head in a bucket and dried blood on a nearby mattress. A search of the home led the police to find other body parts, including a male organ in the bucket and an upper torso in a tote bag. Now, Taylor said she did not intend on killing the victim, but that she was choking him and she decided she liked it, and so she continued to do so. Taylor was taken into custody, and when the police asked her what happened, she replied, "That's a good question. That's a good question." Now, in the complaint, prosecutors say that Taylor told police she and the victim were together all day Tuesday and had been smoking methamphetamine together. And then they were having sex. Now, Taylor said she blacked out at one point and just went crazy and started strangling the victim with a chain and then with her hands. She stated she could feel the victim's heart beating as she was choking him, so she kept pulling and choking harder. She told police she knew the man was dead because his face turned purple and blood came out of his mouth, and that didn't stop her. Anyway, Taylor stated she used knives from the kitchen of the residence and that the bread knife worked the best because of the serrated blade. She also stated that her plan was originally for her to take all the body parts with her, but she got lazy and only ended up putting the leg and foot in the van, and she forgot the head. Things happen. Anyway, Taylor appeared in the Brown County court on Tuesday. Her bail has been set at $2 million, and she remains in custody at the Brown County Jail. She is scheduled to be back in court in 3 weeks. I mean, that's the good stuff, right, ladies and gentlemen? Not trying to be insensitive because there's a dead guy there, but come on, isn't that what we really always like about this kind of stuff? And it makes you wonder, why did they do it, right? Isn't that really the reason why we love true crime stuff, is why did they do it? And in her case, old Taylor doesn't know either. That's a good question. All right, and moving on to our dumb criminal of the day. Let's get to it. Officers in Miami responded to a violent dispute between David Martinez, 40, and his brother. Martinez's brother told the cops that his brother had been acting strangely since last night and threatened him with sharpening a large kitchen knife. I wonder if it was a bread knife. Anyway, he told him he was going to, quote, cut the gay out of him, end quote. When the brother tried to leave the house, Martinez followed him out, grabbed him, and told him to get back in the house. The victim returned to the residence, but was eventually able to exit the location and had a friend contact the police. Martinez was arrested for aggravated assault with a deadly weapon, kidnapping, and false imprisonment, all of which are felonies. He's also charged with 2 misdemeanor counts of resisting. Now he's being held in the county jail on a $22,000 bond, and maybe if we had a little more context, he could be charged with a hate crime as well. Well, Mr. Martinez, you are a dumb criminal of the day. Congratulations, but at least you didn't chop anybody up into little parts and have no idea what the hell you just did. All right, thanks for watching. We'll see you next time on Crime Talk.